Order in the court. The Supreme Court of Florida is now in session. The Honorable Chief Justice Charles T. Kennedy presiding.
Good morning and welcome to this session of the Florida Supreme Court. On today's docket, we have one case, the case of Steiger versus the state. Counsel for the petitioner is now recognized.
Thank you. Good morning. May it please the court. My name is Jared Brown and I represent the petitioner Henry Steiger. A jury convicted Mr. Steiger of second-degree murder of Cassandra Robinson after his trial lawyer, Paul Hamlin, allowed the prosecution to admit numerous improper collateral crime references, including being on probation, having been charged in a federal case, as well as an attorney-client privilege statement tantamount to a confession with his attorney, Erica Reed, as well as a lengthy statement given to the police, which was introduced through a witness that could not properly authenticate that statement. Furthermore, Mr. Hamlin also, when faced with an opportunity to properly object and preserve the erroneous admission of the collateral crime evidence, not only failed to do so on numerous occasions, had a conversation with his client on the record, talked him out of asking for a curative instruction, and fully thwarted the ability to preserve the error for further appellate review. It's par for the course of the way he conducted himself during the representation, as at trial of 24 witnesses, of 24 witnesses, 8 were not asked a single question on cross-examination. One of them was the lead detective. 8 were asked less than 1 transcript page, 6, 2 transcript pages or less, and only 2 of 24 had even 2 or more pages of trial cross-examination.
Counsel, this sounds like a great opening for an argument on collateral attack. Can you maybe focus on 924-0513 and tell us how we should be listening to this now as opposed to then? Sure.
So what's very interesting is that the opinion Jefferson in 2000 specifically addresses 924.051 subsection 3, and in doing so recognizes that statute is dangerously close to infringing upon constitutionally mandated appellate jurisdiction. And when evaluating that statute, because obviously there's an interest in not finding statutes unconstitutional, this court read that particular subsection to only mean the contemporaneous objection rule. Why that's interesting is that because at the onset in 1980 of the introduction of the direct appeal 3850, and even subsequent up through 1996, when that statute was introduced, the contemporaneous objection rule had already been in place. And it in no way affected Blanco versus Wainwright. It in no way affected Owen v. State, Warnos v. State, these opinions that predate the Criminal Appeal Reform Act of 1996. So if this one particular subsection that the Attorney General's office heavily relies on was the same prior to 96 because it was a contemporaneous objection rule, therefore the law didn't really change after 1996. Therefore, that statute doesn't in any way affect what took place after it was passed. So in this case, when you look at the opinions that were issued by this court, there's a reason that they don't go into detail. This court wisely recognized that as of 2000, after State v. Jefferson, it had already addressed the issue. It's just very interesting that at the district court level, there's a significant reliance upon this statute. However, at the Supreme Court level, at this court's level, there isn't a heavy reliance even after 1996 on Florida Statute 924.051 subsection 3. And on top of that, the district court, on top of using the standard that, let's say, in Owen v. State 560, Southern 2nd 207, a Florida Supreme Court case from 1990, which again predates the CARA Act.
Mr. Brown, could we look at the language of the statute together?
Sure.
So it says an appeal may not be taken from a judgment or order of a trial court unless a prejudicial error is alleged and is properly preserved, or if not preserved, properly preserved would constitute fundamental error. It goes on to say a judgment or sentence may be reversed on appeal only when an appellate court determines after review of the complete record that prejudicial error occurred and was properly preserved in the trial court, or if not properly preserved, would constitute fundamental error, correct?
Yes, sir.
And that statute has not been declared unconstitutional, correct?
That is correct, sir.
And you haven't made an argument on appeal that it is unconstitutional, correct?
No, sir.
And you agree that we're required to follow the law, and therefore we'd be required to follow this statute as would other appellate courts in conducting their appellate review, correct?
I would agree that the court must follow the law as well as precedent that is in place. In this court in 2000 in State v. Jefferson, the citation is 758 Southern 2nd 661. When faced with interpreting the statute, determined that
looking back at the statute, you've already indicated that these are not preserved errors, and you did not raise a claim of fundamental error. So where is the authority to consider your claimed ineffective assistance of counsel errors in a direct appeal from a final judgment rather than in post-conviction collateral attack?
There are a number of cases that have supported this.
I'm asking about the statute and application of the statute. And I mean, the statute's very plain and clear. Does it authorize us to consider, an appellate court to consider ineffective assistance of counsel claims that are not argued as fundamental error?
It does, having been considered in light of the Jefferson opinion.
So you think that we amended the statute in Jefferson? We didn't declare it unconstitutional.
No, that's correct. The court did not declare it unconstitutional in Jefferson, but what the court did was analyze the statute, look into the legislative intent of the passing of the statute, and then say specifically that the court is reading this statute to just codify the contemporaneous objection rule out of fears that the statute as written could become unconstitutional.
Okay.
And also, I apologize.
That's it.
Okay. I'll point out that in numerous cases at the Supreme Court level have acknowledged the argument without relying upon a 924.051 means of addressing it. In Johnson v. State, 238 Southern 3rd 726, it's a 2008 opinion from this court. There is a reference to a direct appeal ineffective assistance of counsel claim that in no way relies upon a fundamental error analysis. And that case also references Fletcher v. State, 168 Southern 3rd 186, Florida Supreme Court 2015 opinion. So there is a body of case law that postdates 1996 and postdates the Jefferson opinion, which allows for this vehicle of raising the opinion without relying upon fundamental error. And I'll point out that neither the Johnson case nor the Fletcher case have any sort of reference to fundamental error when discussing the direct appeal application of a 3850. I'll also point out that even though we did not raise it, the court always has the ability sua sponte to address any fundamental error should the court deem it fit. We have opted not to argue that particular route. However, it is something that should the court believe that to be the appropriate vehicle and remedy or the argument under the circumstances, we acknowledge the court's ability to raise it and rule in that fashion should that be the case. But applying the legal standard, which predates 1996, even in Blanco versus Wainwright in 87 and Owen in 1990, it seems very clear that there is ineffective assistance that's apparent on the record because the admission of collateral crime evidence is very prejudicial. And I think what's interesting to contrast the situation in which a prejudicial error is objected to, that it's normally going to result in a reversal at the appellate level. In Matthews v. State, 772 Southern 2nd 600, a defendant is accused of murdering his wife. He is ultimately convicted at trial. And a psychologist report references the fact that he was on domestic violence probation. and the simple short reference to him being on probation for domestic violence warranted a reversal of this individual's conviction for murder. And even in a situation in Rodriguez v. State, where 761 Southern 2nd 381 Florida 2nd District 2000, there is a situation where a defendant is testifying, and while testifying admits to being a felon, but the prosecutor oversteps the bounds and improperly impeaches by asking the defendant to name the specific felonies when that's otherwise not allowed by law. The defense attorney doesn't object. The defendant, who's on trial for robbery of firearm, admits that he had previously committed a robbery firearm, and that was found to be an error meriting reversal, even though there was no objection, and there's not even a reference in that opinion either to there being fundamental error, which seems to be in line with the line of jurisprudence from this court, which does not require fundamental error to justify a reversal. And the reason that those are significant is because, one, it bakes in the prejudice. You have an objection to one simple reference, and we know there's a reversal. You even have a situation that's egregious that merits a reversal. While in Mr. Steiger's case, Mr. Hamlin knows what's coming. There's a recording of this statement that is given to the defense. This recording has obviously prejudicial statements because Mr. Myers, the prosecutor, admits that he had to redact a lot of the inappropriate information out. He doesn't do so. So there's one, an error by the prosecution. This is a different situation than a case where maybe a defense attorney is ineffective for failing to find the 75th potential exculpatory witness. This is one of those situations where the prosecution overstepped its bound, then the defense overstepped its bound, and both did so numerous occasions. It wasn't spontaneous. It wasn't an organic moment that just occurs during a trial. It was planned. It was a video recording. What's on the dress rehearsal is the same as a live show. Everyone knew what was coming.
Counsel, am I right? Am I right that Mr. Steiger testified at trial?
Yes, sir, he did.
Okay, so isn't it well settled that the jury was entitled to disbelieve, reject, and indeed believe the opposite of his testimony? In other words, doesn't the fact that he testified at trial weigh heavily in our consideration of the record before us? Wouldn't you agree this would be perhaps a better case for you if he hadn't testified at trial?
I would agree that his testimony is certainly damaging, and I can imagine if I was counseling him, I would have done my best to advise that he not testify, certainly. However, I think there are a lot of things that show an otherwise weak case because there's no one who sees him do it. There is a body that's only found way months later down the road, and the decomposition of the body doesn't allow for anyone to come up with a means of death. The medical examiner testifies there's no bruising or injury of any kind they can find to the body because the decomposition is so bad. So I would agree that what he says after the fact is clearly troublesome, but that shouldn't in any way obviate the prosecution during its case in chief to have its obligations to do what it's supposed to do properly. They couldn't predict that Mr. Steiger would testify in the fashion that he ultimately testified. They're still, they tried to argue at one point that his initial statement could have been authenticated by Mr. Steiger's subsequent testimony, when there's no reason in the case in chief that the prosecution could have admitted that statement, where Mr. Steiger clearly is dishonest with respect to what happens with Ms. Robinson. The statements that he gives are clearly contradicted by the police investigation that unfolds. So there's very obvious prejudice by admitting a statement separate from the other video recording where on numerous times they mentioned that Mr. Steiger says, I can tell you that the situation I'm in with the feds could potentially be never ending. And by the way, what's very interesting about that is that this is not just a situation where it's one time or two times or three times or four times, it's 5. It comes up like 10 plus times. And it doesn't just happen in a row. The initial improper statements happen on transcript pages 600 and they end at 602. But then they come up moments later again on page 611. And then they come up again on page 621. So there's even time after the first series of inappropriate statements for Mr. Hamlin to collect himself recognize that inappropriate things were introduced and object. The prosecution also had the time. The prosecution admits after the fact that they missed certain statements in this recording that they should have and attempted to redact, yet the jury still heard it. And they admit that when they want to give the evidence to the jury in deliberation, they're going to redact that stuff out so the jury doesn't have the full statement that was just heard in evidence. He admits that he's on probation. There's a conversation where the lead detective says that, I apologize, the second detective who's with Detective Alverson, Detective Wilhite, says that he tries not to deal with the feds on anything and literally says, yeah, they scare me. So you even have the police investigating this individual for murder saying that he is scared of the people who were previously investigating Mr. Steiger for an unrelated crime. There's a reference by Detective Alverson that Mr. Steiger is on probation. He says, quote, maybe your probation officer is the one to blame for not following up. So the jury doesn't, I mean, we obviously make a joke out of saying something's a federal case. We know we have a federal case. We know he's on probation. We know that the local law enforcement is scared of the feds. And then he says, however, they are not in the business of viewing me in the best possible light. Their business is to view me in the worst possible light and then to ask me to defend myself. And I have been unsuccessful in the past. So then
Counsel, you have now moved into your rebuttal time. You may continue, but you are consuming rebuttal time.
Thank you, Your Honor. Chief Justice, I appreciate that. For the reasons I had previously mentioned, 924 in no way affects the current statute as Jefferson renders it irrelevant to the circumstances. I would ask that the remainder of my time would transfer to rebuttal, and I'll reserve.
Thank you. Counsel for the state.
Good morning. May it please the court. My name is DAREN SHIPPY. I represent the state of Florida in this matter. We have framed the claim that I think this court is interested in as whether general law that was enacted in Florida Statute 924.051, as well as this court's holding from 1974 in State versus Barber, preclude the defendant, in this case, from directly appealing what they claim are trial counsel's alleged ineffective assistance. The question that arises from this is, how did we get here from there? The reason I ask that question is in light of this court's decision from 1974 in State versus Barber, followed by the enactment of 924.051 in 1996, why are any claims of ineffective assistance being raised on direct appeal? I'm not going to go through and cite all the cases that we've already cited in the brief, but multiple cases throughout this state have recognized the limitations of 924.051. What they've been stuck with is this court's decision starting in 1980 in Foster versus State, which is the first time this court ever recognized a claim of ineffective assistance of counsel on direct appeal. Before that, in State versus Barber, I'll respectfully suggest this court got it right when it said in order to have an appeal, there needs to be an adverse ruling by the trial court. By default, if you are raising a claim of ineffective assistance of counsel on direct appeal, you do not have an adverse ruling of the trial court.
There have been cases subsequent to that case that went the other direction on that, right?
Well, two cases that I have that I cited in the brief from this court would be Foster versus State as well as Monroe versus State. There's been a lot of discussion by this court, but I don't recall that this court has actually found ineffective assistance of counsel on the record in a direct appeal other than in Foster and in Monroe. Plenty of cases throughout the state of Florida have latched onto those opinions and run with them. In my opinion, in violation of not only State versus Barber, but as well as the enactment of 924.051, which—
What if the court, instead of doing it by a case law, could this court have a rule that would govern, we have rules that govern appeals of ineffective assistance of counsel claims. That's in our rule of appellate procedure, how those get filed. are governed by our rules of criminal procedure. So how those claims get made and how they're done on review, are those a matter of procedure or are they a matter of substance controlled by the legislature?
I believe it's substance controlled by the legislature, and that starts with Florida Statute 924.066, which is the basis for the motion for post-conviction relief that we all recognize, and as we call them, maybe 3850.
So it seems to me that the legislature has required there to be a harmless error statute. There is, and we apply a harmless error. But isn't how appeals of ineffective assistance of counsel and how they're done, when they're done, what they look like, all that controlled as a matter of procedure by this court according to our rules?
I still think when the claim is brought is a substantive matter, the same as the legislature determines when a civil action has to be brought by or anything of those nature. I think it's a substantive matter concerning the ability and the right to do so. Perhaps
But counsel, let me ask you this: where in the statute? I mean, if I understand what Justice POLSTON is asking, he's not asking about something that's in the rules now. He's asking about something that could be in the rules, and I'm trying to understand what you think in the statute, and it may be there. You may have a very clear answer, but what in the statute would preclude us from having a rule that allowed bringing claims of ineffective assistance of counsel that are apparent on the face of the record earlier than they can be brought under the current post-conviction process? I mean, one of the things that the legislature focused on is that and again, I'm not saying that this affects the outcome in this case, but they have expressed a general intent to ensure that all claims of error are raised and resolved at the first opportunity. And to the extent that we wanted to have a rule that would allow this kind of claim to be brought earlier, I mean, before a conviction and judgment and sentence are final, what in the statute would preclude that?
The statutes itself, it's set forth in 924.051, and Justice Lawson already did it, read it, which says an appeal may not be taken from a judgment or order of a trial court unless a prejudicial error is alleged and it's properly.
Counsel, I just don't think you're understanding my question. And I don't know, Justice POLSTON explained it. I've explained it. I'm at a loss to how I could explain it better. So I will just give up.
Well, counsel, I mean, I think the issue for you though is, I mean, I think what they're talking about wouldn't even be an appeal. It would be a new claim, right? And so
in the first instance, it would be just a claim of ineffective assistance. It would go through the process, except in an earlier phase than is permitted now.
And so part of the issue, and you raised this in your brief, counsel, is that, you know, the nature of those claims usually requires hearings that, you know, it normally, you know, you want the lawyer to sort of have the opportunity to explain what they were thinking. And so it would be, you know, you may be able to conceive of some outlier cases where the court would say that there wasn't any need for that, but it would be a very unusual way to handle ineffective assistance claims, to let someone just raise them in a sort of, as I guess, some sort of parallel to an appeal type proceeding.
I've got four things to say, and I hope this may get more to your question, Justice CANADY and Coryell. Number one, the basis for appellate review is an adverse ruling by the trial court. You do not have that when you allow claims to be raised as they're currently being raised on direct appeal. You don't have it. It doesn't exist. Number two, and this is equally important, this court has announced that the standard of review for a claim of ineffective assistance of counsel is a mixed standard of review. That means that, and built into that standard is, you have a trial court factual finding that eliminates things. And as long as there is substantial competent evidence upon which that trial court has made those factual findings, you're bound by those. You do not have any factual findings the way you are allowing these cases to now be conducted, which is someone's making a claim because someone didn't raise an objection. Number three, there is no opportunity for the state or the trial counsel. At this point, when that claim is raised, they become equal parties to the defendant to challenge that claim with evidence, not with argument, but with evidence. What was going through the attorney's mind? What was the thought process? Was there any discussion in advance? All of those things. And fourth, there's a different standard of review. It's a lesser standard of review to raise a claim as ineffective assistance compared to fundamental error. And if it wasn't, then every objection, we could just simply overlook it and say, well, he didn't object, so let's just raise it as ineffective assistance. We'll disregard what the legislature said. We'll disregard what this court has said, that said that unpreserved claims are meant to be brought by fundamental error arguments, not by ineffective assistance of counsel.
Whether something is whether something preserved or not, is that a matter of procedure or substance? Who gets to decide that?
Whether it's preserved or not?
Yes.
Well, the appellate court would make a decision as to whether or not it was preserved, unless there's a stipulation between the parties involving perhaps the court down below.
Is that a procedural matter or substance? Who gets to decide that? The court or the legislature?
Well, the court would decide whether or not it's preserved. The legislature's given you the parameters by which you are to consider appeals. Are they preserved or are they fundamental error? That's what your starting point is, not ineffective assistance of counsel claims raised on direct appeal. They've told you this is when an appeal may be raised. Number one, is the claim preserved? And if it's not, does it constitute fundamental error? And
it seems to me, counsel, that the ineffective assistance of counsel claim that we're talking about here really is not something that's a matter of direct appeal. It's really, so it's not really an exception to the statute, but maybe an exception to our rules about how we deal with post-conviction claims. And the court apparently, at least as to Foster, may have attempted by case law to carve out an exception to what has to be done according to our post-conviction rules as a matter of what must be filed and is up on appeal. What's your reaction to that?
Well, I do think Foster carved out an exception, and I think it was wrong in doing so. And I think Justice Adkin in his dissent, citing the Barber, explained to his other colleagues why it was not right, because there was no ruling from the trial court that you're looking at. You're simply looking at a big, broad record with no other information. You've got no factual findings by a trial court or anything, specifically that should have been conducted in the 3850 proceeding. So Justice Adkins, you didn't have a uniform decision in that case. Justice Adkins recognized State versus Barber controlled Foster, but is that responsive, sir? Okay. All right, so we talked about Barber. We talked about the enactment of Florida Statute 924.051, which sets out the procedures. And let me simply respond to what counsel has mentioned as far as State versus Jefferson. You'll find in State versus Jefferson, because the state cited it in its brief, in the discussing 924.051 says, in order to constitute reversible error, the error must be, number one, preserved for review or amount to fundamental error. So any suggestion that there was some other holding is simply not accurate with what this court held in State versus Jefferson. This court has also noted all the way back in 1983, cited in the opinion, cited in our brief, Williams versus State, recognized that neither the state nor the trial counsel was given the opportunity to refute allegations, and the trial court should resolve issues of fact. This court, or any other appellate court in this state, is not set up to resolve issues of fact. This case is a great example of that. Contrary to what opposing counsel says, there are a lot of things based on my personal experience and having tried 20 murder cases. As a defense attorney, I've got an idea about what may probably have happened down below that counsel is now claiming about as some sort of harmful error, which is not true. So you've got the statutory basis for following what this court did back in State versus Barber, which is you need to have an adverse trial court ruling to appeal. Unless you're going to craft some additional rule, you'd have to make a decision, or I guess there'll probably be some litigation later on as to whether or not the rule is consistent with 924.051. It's the state's position. That is the basis and the only basis for the defendant in a case to challenge a ruling. That's it. there is no limitation on the defendant by having to follow the procedure that's contemplated by 924.051 and added to that 924.066, which is the post-conviction statute. There's no harm to the defendant. If there was no form of relief whatsoever, no ability to raise the claim, then perhaps there's something to listen to. But there is a procedure set out. This court recognized it long ago, and that procedure existed all the way back in 1974. And somehow or another, the court got off track. And what I'm asking the court
Let me ask you, counsel, if I understand what you're saying, you just think this category of ineffective assistance that is clear on the face of the record is a bogus category. You don't think there is any such thing?
I believe that first of all, if I was the attorney of record,
That's not a trick question.
I agree. I agree with you that there is no ineffective assistance counsel on the record.
I was just asking if that was your position. I just want to make sure that was your position. I'm not saying I'm not asserting that as a position of my own, but
I agree with that. I agree with that in this case. If we get into a debate about what the lawyer did or didn't do, then you've played into my hands that we need a hearing to deal with that.
Well, I wasn't even asking about this case. I was asking about just in general, you would take the position and the state would take the position that there can never be any such thing as ineffective assistance of counsel that is apparent on the face of the record.
Based upon the way we define it, yes, I agree with that. Because yes, I could explain it further, but I'll agree with you to that extent if that will answer your question, because there's more involved than just reading the record. There's simply more involved than just reading the record. So what the state is suggesting that all of this leads to, let me get back to something else that may be an analogous situation. When someone is arrested, taken into custody, typically there's a probable cause affidavit that's placed in the court file. The trial judge or the first appearance judge is going to look at that, make a decision whether there's probable cause for arrest. If we didn't need to have a trial in the case, and if anybody else was simply looking at the probable cause affidavit, we could look at that and say, you know what, based upon what's written in this probable cause affidavit, he's guilty. Why do we need a trial? Well, we need a trial because sometimes what you see doesn't tell the entire story. And we give you that opportunity.
Oh, we also need a trial because the Sixth Amendment says so, right?
I understand. I don't disagree with that. But the analogy is we're reading a piece of paper, which is you're reading a record, and you don't have all the information because you don't have any input from the trial counsel. You don't have any argument from the state that's based upon evidence. So the probable cause excuse me, yes.
Mr. Shippy, just one thing that I always found intriguing, because I read once a case in Texas where apparently the lawyer representing a death penalty type of case showed up pretty much intoxicated every day for court and did nothing. Pretty much the oral argument, the opening statement was incomprehensible and so on and on and on. In a situation like that, whereas before us on direct appeal, and the record shows that defense counsel did nothing, just sat there pretty much the entire trial, did absolutely nothing. And that may be an extreme example, but in a situation like that, what do we need a hearing for?
Well, I guess
what's going to come out of the hearing? That he asked one little question someplace? What do we need a hearing?
If your questions are related to whether or not a defense attorney has to ask questions of every witness, I'll tell you flat out no. And actually to respond to opposing counsel.
Well, he did nothing. He sat there the whole trial. No opening statement, no cross-examination, nothing. Just sat there.
Well,
what do we need a hearing?
You are presuming, I guess, that there was a basis to object. The basis to object would have been prejudicial error in your analysis or your scenario. So, I mean, I think there's more information that we need to have before we can answer that question. And if we assume that he was drunk or whatever, I'd be a little bit hard pressed to know why a trial judge wouldn't have recognized that and dealt with it, which has happened in the past. But the idea that you have to object doesn't exist. The complaint of opposing counsel that only one question was asked of the lead investigator reflects an ignorance of how trials are conducted, which is
Counsel,
Counsel,
I'm sorry to interrupt you. I think these questions have sort of gotten you kind of off track though.
Okay.
So if we're talking about an appeal, there's two paths. There's preserved error and fundamental error. So, and this is an appeal. So part of the answer to Justice Labarga might be that there probably was fundamental error in a case like that. Now, they've also asked you questions about sort of jerry-rigging, sort of after the fact, a brand new post-conviction ineffective assistance of counsel claim that's brought for the first time in an appellate proceeding. And if the court wanted to consider doing a rule like that, that would be our problem. And who knows whether that could ever possibly be a wise thing to do. But this case is not that case. This is an appeal. Your opponent on the other side, who's obviously doing a great job with the record that they have not brought a post-conviction claim. They've brought an appeal. And so you've got two boxes, and those are the boxes that I think you need to sort of focus on.
Well, and hopefully we did that by arguing that the statute that applies to this appeal is 924.051. And the statute that would apply to a claim of ineffective assistance of counsel, which would be a post-conviction claim, is 924.066. And the relative rules that go with those. So you've got direct appeal rules that are reflected in the Florida Rules of Appellate Procedure, and you got rules that apply to post-conviction, which is 3.850, and in death penalty cases, 3.851. I can make it as simple as that. And it looks like I'm just about out of time. So what the state is asking this court to do is to recognize that counsel in this instance did not raise any claims of fundamental error. As a result of that, based upon this court's decision from long ago, as well as 924.051, the appeal should be rejected. Receipt from Foster and Monroe, or if Foster gives you a problem because it was an actual conflict of interest situation, limit it to that fact. Announce a rule that from here forth, direct appeals of ineffective assistance of counsel claims are not going to be recognized in the state of Florida. Thank you for your time.
Right. Thank you, counsel. We'll hear a rebuttal argument.
Thank you. I think the interesting thing that was said by the Attorney General with respect to whether this is a procedural substance issue, it hits it on the head. The court can decide this issue is whether it's preserved or not. If this is procedural.
Well, actually, counsel, but he didn't talk about this, but this is regulating the substantive right to appeal. And there's a statutory definition of what preservation is. And the legislature has said, you know, in order to be able to appeal, you have to have done X, which is, you know, either fundamental error or what they define as preservation. And so I think it's not obvious whether really that we can just sort of put that in a procedural box. I mean, you know, one maybe could argue that, you know, the definition is somehow in conflict with this constitutional right to appeal, but the legislature obviously has treated this as a substantive issue in terms of the gateway to the appeal itself.
I would agree, and that's why the Jefferson opinion is important when it touches, it discusses how the statute touches upon the constitutional conference of jurisdiction. And that's where the fact that Article 5, Section 4B mandates the right for the appeal, that's what ends up becoming the hallmark of the discussion in Jefferson, whether the legislature is encroaching upon what it can do constitutional. I also want to point out along those lines that the court still has inherent powers, his will to act, and that as Justice Labarga had mentioned, there are situations, and granted it was an extreme hypothetical, where there could be somebody so obviously ineffective that as a matter of policy, what's in place
How do you respond to Justice Muniz's clarification on that? That would be fundamental error.
I agree that it's certainly complicated. It's certainly convoluted, and there's a reason that we're here right now discussing this, because it's very interesting and it's tough to get through. But I think the ultimate issue has to be that the way this particular statute has been interpreted, it may seemingly in its plain language say one thing. However, when the court did a deep dive of the legislative intent and looked into what this statute means with respect to an appeal, that obviously preservation for the sake of this is different than what otherwise would be preservation for the sake of a standard appeal, because as the court had, Chief Justice Canady had mentioned, discussing an issue at the first opportunity that you could. Well, for an ineffective assistance of counsel, this is the first opportunity that you can raise and address an issue, because it doesn't make sense to expect an attorney who is not observant to the fact that a prejudicial error had just happened would then also realize, hey, let me object to me not doing what I was supposed to in the first place. This is, in effect, a first opportunity, which is why, as the justices were discussing, there's like a separate vertical that these claims fall into where standard appellate practice doesn't completely govern them. And because the current state of the law as is allows...
Counsel, you have consumed all your time. If you would sum up in about 30 seconds.
Thank you, sir. Because the current state of the law allows, through a direct appeal, Mr. Steiger to address the ineffectiveness on the face of the record in the fashion which he has raised it, we would ask that the court keep the rule in place that allows this, recognize that it is separate from the way a otherwise typical preserved claim would be raised if objected to at the lowest level, and remand to the trial court for a new trial, because on its face, Mr. Steiger has met the legal burden for reversal. Thank you.
Thank you, counsel. We thank both of you for your arguments in this case today. That's the only case on our docket for today. So this proceeding is now concluded.